We continue with dispositive provisions, and this class will specifically look at the spendthrift provision, which is the settler's provision designed to keep the beneficiary's creditors out of the trust assets. So by way of review, we've looked at generally trust provisions, recognizing there's both income and principal that needs to be dealt with. There are mandatory and discretionary aspects of either income or principal. You need to be able to look at the trust terms and evaluate whether or not the beneficiary is entitled to something under a mandatory distribution or discretionary, in which case the beneficiary is not entitled to anything. It is up to the trustee, and absent an abuse of discretion, the trustee's decision will hold. We've also looked at the power of appointment, which is another flexible trust provision that the settlor can include, and it allows the donee of a power of appointment to ultimately designate the takers. You have to look at the power of appointment and decide, is it testamentary or inter vivos, whether or not a specific reference is required, and whether or not the donee made a permissible exercise, and if not, is there a taker in default that will take the property. All right, so let's talk about the spendthrift provision. Can you identify it amongst the trust terms? Looking for language that says the trust interest of the beneficiary can't be assigned. Ideally, the settlor includes a trust spendthrift provision so that the creditors can't use the trust assets for collateral. We'll take a look at the Bacardi case, because the Bacardi case is the alimony case, which has the exception to the spendthrift provision. Why are they allowed to be valid? Why is the settlor allowed to protect the settlor's assets? It's because it's the settlor's money. It's not the settlor's creditors, and it protects the trustee from being able to manage the property without being concerned about the beneficiary's creditors. The theory behind it is exactly that we want to honor the settlor's intent. The settlor has the ability to protect his or her assets that he or she is providing for beneficiaries and limiting it. On the other side, is that doing nothing but insulating the beneficiaries from the beneficiary's creditors? So that's sort of the balance. Keep in mind there are some exceptions, some special creditors, in which case we pretend as if the spendthrift provision did not exist. First and foremost is a self-settled trust. A settlor cannot set up a trust for the settlor, him or herself, with a spendthrift provision and try to get away from paying the settlor's creditors. So they are not valid in a self-settled trust. Settlor sets it up, settlor is the beneficiary. If the creditor is a provider of necessities, food, shelter, and clothing, we want to encourage those types of creditors to provide those types of services, so they too will have an exception to the spendthrift provision. And then public policy creditors like alimony, child support, and taxes. If we didn't allow for the trust assets to be used to pay those types of legal obligations, then we as the public would have to pick up the tab. And so therefore they've carved out an exception for those special creditors, which are more like a legal obligation. It really comes down to sort of a balancing between the settlor's intent and public policy as to whether or not exceptions are carved out. Think about the Wilcox case and how that might have been different had there been a spendthrift provision. Take a look at the Bacardi case. That's the first case on spendthrift provisions. It looks at the alimony exception. interestingly enough, even as an exception, this special type of creditor cannot have access to any more than the beneficiary himself or herself could have had. So you had a situation in which you had the wife going after the husband for back alimony, and the husband was the beneficiary of a spendthrift trust, and the question was whether or not the alimony creditor, the wife, could reach those assets. And in certain limitations, yes, they can get as much as the beneficiary himself could get. Make sure that you are recognizing the spendthrift language there and keeping in mind that we've got competing public policy issues here. Should we honor the spendthrift provision and carry out the settler's intent, or should we invade trust principle to pay this type of creditor? And there's somewhat of a balancing here. The court ultimately concludes that a spendthrift trust should be allowed, but only as a last resort. They don't want people to come to the spendthrift trust first and foremost because it might be easier to collect. If the debtor has his or her own assets, those must be, efforts must be used to get to those assets first. So this would be sort of a last resort. And there will be limitations. It's not as if this alimony creditor could sort of completely get paid, only to the extent that the beneficiary could reach the assets himself or herself. If discretion is exercised, then it may go over to this special type of creditor. Should it be boilerplate? Well, pretty much in every trust I've ever prepared, a spendthrift provision is one of the advantages, one of the reasons why people use trusts. Under common law, it prevented premature termination, but that in fact has been changed. So I would say the general rule is that a spendthrift provision is boilerplate in just about every trust. There's really no reason not to include it anymore. The next case deals with a different type of creditor, a tort victim creditor. So the beneficiary of the trust has in some way harmed the victim, who is now trying to collect against the trust. And this tort victim wanted another public policy exception carved out. What happened, however, is that it was purely discretionary trust with a spendthrift. So make sure you were in a position where you could look at the various provisions of that trust and identify them. And identify the spendthrift provision, which is quite often tested on the bar exam. And look at the various arguments that are made by both sides. And unfortunately, they did not carve out a new exception, unfortunately for the tort victim. Fortunately for the settlers of the world who know that their money can still be protected, a spendthrift provision will protect the trust assets from tort victims, even if they have a bad beneficiary. Looking at the various arguments that the tort victim made, but unfortunately for the tort victim was not successful. Maryland had a very similar case in 2003. In fact, the beneficiary had killed the tort victim, and the estate went after the bad beneficiary's trust. And like the prior case, Maryland has not extended exceptions to the tort victim creditor. And this, in fact, has been codified by the Maryland Trust Act. There are exceptions which are laid out very nicely in the Duval case for alimony, child support, and taxes, but nothing in terms of the tort victim creditor.